Hi, I'm Daniel Finley with Finley Law and thedivorceguy.com, and in this webinar we're going to discuss the process of discovery. It's an important topic, how to prepare for a divorce. Discovery should be conducted in every divorce case. Oftentimes not doing so can lead to very serious consequences in terms of a fair deal. So what is discovery? It's the mechanism by which we discover relevant evidence. For example, what is there to divide? It's hard to have an understanding of what you're entitled to in a divorce if we first don't know what the nature and the extent of the estate is. Maybe you have issues regarding debt. What was that money spent on? What's the value of the company? Is my spouse having an affair? These answers are obtained through the process of discovery. All right, so one of the major reasons to conduct discovery is to understand what the contested issues are. Are you agreeing to the proposed custody and parenting time arrangement? If not, why? Help me understand exactly what your employment pays you. Are you receiving deferred compensation? Are there stock options? And to help prepare a marital balance sheet, one of the most important things to do in a divorce in analyzing and discussing how to divide assets and liabilities. Here's a sample marital balance sheet. Here we've identified what the assets and liabilities are, and then we can change the percentages in terms of the allocation of husband and wife to help assess who's going to get what and should there be a cash equalizer to help determine not only what is there to divide, but how we divide it. Discovery is an incredible tool in helping us understand values. Do we need a business valuation? What is the value of that company? In this case, we called it Acme Products, Inc. I guess I'm a fan of the old Bugs Bunny cartoons. Notwithstanding, the key learning is in order to understand how we're going to divide the assets and liabilities, you have to first have an understanding of what they are, and discovery is the process by which we do that. Okay, so here are the different types of discovery. And you could say that there's 5 or there's 6, but really I think of them as 4. First is the Verified Financial Information Form. These are mandatory disclosures. They have to be exchanged in every divorce case. It's a questionnaire. They're required within 28 days after someone's filed a responsive pleading, typically an answer to a complaint for divorce, and they ask basic questions. Interrogatories, I want you to think of the word to interrogate. These are written questions which must be answered under oath, subject to the penalties of perjury. There are specific rules relating to the number of interrogatories for each set. It's 35 in domestic relations actions. Interrogatories are also accompanied by requests for production of documents. That's why there are probably really only 4 in this instance. A request for production of documents may say how much you earned, where do you work, and by the way, produce your last 20 pay stubs, for example. Depositions, you may have seen them before. It's live testimony, typically taken with a court reporter, sometimes even by video. And the nice thing about a deposition is that the lawyer has an opportunity to ask follow-up questions. You don't have to wait for a written response. You can say, well, wait a minute, you said you're not receiving a stock option, but you have deferred compensation. Help me understand why. A deposition is a wonderful way to get answers to very complex questions. A subpoena is a court order. It's typically issued to a third party to do something, such as to produce bank records, statements, and so forth. Okay, here's a sample snippet or cutouts of a domestic relations verified financial information form. We often call those a VFIF. I just cut and pasted different portions of it, but you can see it's asking for the value of an account now. What was the balance 90 days ago? This could be a bank account, a credit card account, IRA, 403B. The idea is to have these initial disclosures early so that we have something under oath saying this is what we have, so that we can start a meaningful discussion about how are we going to divide assets. Verified Financial Information Form, like I mentioned a few moments ago, is typically exchanged 28 days after the first responsive pleading. Here are some sample interrogatories. These are written questions. And this question number 3 asks questions related to Acme products, asking for the last 5 years of tax returns, expense reimbursements, and so forth. And there's a request to produce 20 most recent paychecks or pay stubs. We may even ask questions related to extramarital sexual contacts or an affair. Oftentimes, fault is relevant in a divorce. All right, and here's a sample subpoena. This is a court form, and in this case, we're asking Ally Financial to produce records. We usually have an Exhibit A that identifies those records. A subpoena is a court order requiring, in this case, Ally Financial to produce documents. Sometimes we use a subpoena even against an individual to provide documents or to schedule their deposition, oftentimes to a credit card company. Maybe the information we received in the Verified Financial Information Form is ambiguous. Or maybe you saw a statement come in from a bank that you never knew about and that your spouse didn't disclose in their VFIF. We could issue the subpoena to get information such as any account bearing the signature of whatever your spouse's name is, or signing authority on that, or in which they have made a withdrawal in the past 5 years. The goal of discovery is information, understanding what are the issues, what is there to divide, and then we can have a meaningful discussion about how to resolve a case. It's hard to resolve a case before having answers to questions. All right, so what's the penalty if you fail to answer or lie? Well, the court can hold a party in civil contempt, which is to compel compliance, or criminal contempt, even to punish jail time. And failing to answer discovery can also lead to negative inference being made by the court. Maybe the court is going to say, you know what, you say that the balance of that account is $500, but when we asked you to produce it and your spouse is saying it was $25,000, I'm going to infer, based upon your failing to answer the discovery request, that the actual balance as of the date that we're dividing these accounts is in fact $25,000. Because why else would you fail to answer these questions? And most importantly, lying under oath is a felony in Michigan. It's a 14-year felony. You literally can go to jail for a maximum time of 14 years for lying under oath. Does it happen often? No. Is there often a penalty for perjury? Yes. Typically in a divorce case, the penalty is a sanction, a financial sanction, or even awarding the asset to another party. All right, so here are some guidelines in terms of answering discovery. Obviously, don't lie, but only answer what is asked. Oftentimes, we have clients volunteer information that leads to more questions. If a specific question is asked, narrowly answer the question honestly. Always review your answers to discovery requests. You can't do that necessarily to deposition when it's live, but when they're written or in their responses, always review these answers with your lawyer, just so that the lawyer can verify that you're answering the information correctly and you're not volunteering information that would hurt you. A lawyer should never ask you to lie. In fact, it's illegal and inappropriate and unprofessional for a lawyer to do so. But a lawyer can help you formulate your responses that are both honest and protect your interest. Preparation is always key, especially for a deposition. If I have a client that's being deposed, I spend a lot of time with that client beforehand, talking to them about how to answer questions, specifically to wait until the question is asked, don't volunteer information, for example, and narrowly answer the question that's being asked so that you don't go down a rabbit hole of exposing you for some other form of liability. Preparation in a divorce case is always key. It's important to be prepared. Discovery is one of the most important tools in the toolbox of a lawyer. It's how lawyers discover hidden information, how we uncover fraud. It's the detective work that's done in preparing a case, understanding the nature, the extent of the estate. Sometimes we can get people to admit things, even by way of a request to admit. That's often accompanies in interrogatory questions for production of documents, verifying that the disclosures are true. After all, if a divorce is imminent, you want to make sure that the deal is fair and that you understand what there is to divide. How are you going to settle if you know if it's a good deal or a bad deal if you don't understand what the exposure is, what the nature, the extent of the estate is, what is their ask regarding custody or parenting time? I'm Daniel Findling with Findling Law on thedivorceguy.com. Let it be our privilege to help you.